how long does it take to get criminal discovery in the state of Oklahoma? I'm Tulsa Attorney James Worth, and that's the question that we have. Actually, the question is a little bit more detailed than that. It notes, what happens if your attorney seems to be giving you the runaround about getting discovery, or perhaps the DA is giving your attorney the runaround regarding discovery? So what are the rules? What is a criminal defendant, someone being charged with a crime in the state of Oklahoma? What are they entitled to regarding discovery, and what's the timeline for that? Okay, so there's a main statute dealing with criminal discovery in Oklahoma and what the defendant is entitled to. As far as the timing of that, I'm going to read that. It's Section 22, Section 2002, and that is Subsection D. And what that says is time of discovery. And it says that motions for discovery may be made at any time, at the time of the district court arraignment or thereafter, provided that requests for police reports may be made subject to the provisions of Section 258 of this title. However, a request pursuant to Section 258 of this title shall be subject to the discretion of the district attorney. All issues related to discovery, except as otherwise provided, will be completed at least 10 days prior to trial. The court may specify the time, place, and manner of making the discovery, and may prescribe such terms and conditions as are just. Okay, so that's a lot of information there. But long story short, we've got two types of cases generally that go to the court, criminal cases. We've got misdemeanors and felonies. This talks about you can request discovery at district court arraignment or thereafter. That is specified, that is for felonies. If you are charged with a felony, you go through the process of arraignment, then a preliminary hearing, and then you're bound over, and that's when you have district court arraignment. So this is saying that formal discovery requests can be made once you're at district court arraignment forward. For misdemeanors, you don't have a preliminary hearing. Your arraignment essentially is your original appearance. Arraignment is your main one. So you can do discovery motions pretty much off the bat in a misdemeanor case. Then it talks about Section 258 discovery. What is that? Well, that's preliminary hearing discovery. And it's before the preliminary hearing, you can request police reports, but like the statute says, that's discretionary. The prosecutor does not have to provide that prior to the preliminary hearing. They don't have to provide you anything. Now, if they don't, that means that the preliminary hearing cutoff is not applicable. So you or your attorney has more leeway in asking questions and basically doing kind of discovery as part of the preliminary hearing. If that is not provided at least 5 days prior to the preliminary hearing. Then it talks about deadline. Essentially, all discovery issues need to be resolved at least 10 days prior to trial. So, long story short, there's nothing in the statute under Oklahoma law that guarantees you any discovery until 10 days prior to trial. So, but you can file the request and the judge can grant other deadlines as are just. So if I'm in a case, my defendant in a case, and we're looking at getting discovery, this is what we're doing. So first off, we want to get the information. That is the formal charges. That's the complaint of the state that lays out what the charges are. That's available from the moment that they file. As part of filing that, there's going to be a warrant for arrest that's going to be based on an affidavit. We want to get a copy of that affidavit. You can get that from the court clerk. That is going to be on file along with the information, although there's a little bit of delay from when that is filed. Then we want to put in, it's a felony, we want to put in our request for preliminary hearing discovery under Section 258. Generally, in most counties, they do provide that. It's not always complete, but at least you get some police reports to have some ideas. But keep in mind, under Oklahoma state law, they're not required to provide it. Then once we get post the prelim, or if it's a misdemeanor case, we put in a request for discovery and we can set it for an Allen hearing, try to get some deadlines set. Because the statute just says this all needs to be resolved at least 10 days prior to trial. We don't want to wait until 10 days prior to trial to find out what we're dealing with here. We want the judge to set a deadline that is earlier. And then when that deadline is set that is earlier, we want the court matter passed to that date of the deadline or shortly thereafter for an Allen hearing where we can verify that everything is received. So that's kind of how we go about trying to get discovery more quickly. But as far as what is required of the state timing-wise, if you do nothing, basically they can just provide things 10 days prior to trial. But you do want to be proactive, request the stuff that's readily available, and ask the judge set deadlines earlier than that so you're on notice of everything and there's no surprises when you're doing your trial prep. All right, so hopefully that answers your questions regarding discovery timeline for a criminal case in the state of Oklahoma. If you've got more questions or any other different questions, you'll probably want to talk to an attorney about that privately and confidentially to receive legal advice. To get that scheduled with somebody at my office, you can go online to makelawEasy.com.